This will be video 2, weeks 5 to 6, contracts, and we're addressing the last two elements of a valid contract. And this is a screenshot on the posting, capacity, and legality. I'm going to go through this material rather quickly, and let me explain why. Having engaged in a lot of litigation and regarding contract problems and drafting various contracts, and having done this for quite some time, and hanging out with lawyers in general, it's my strong sense that most of the contract stuff that would be coming into our hypothetical law firm, be it drafting, transactional stuff or litigation stuff, most of it is not going to involve capacity and legality, except perhaps one aspect of legality, which I'll get to. So what I'm going to do is ask you to put together under capacity the concept summaries 13.1, 13.2, and 13.3 on pages 55 to 57 of the book. And they're going to give you those summaries, the essential rules about capacity as they relate to minors, intoxicated persons, and mentally incompetent persons. And those are the three categories of situations which will give rise to a possible capacity problem. And I will feel free to hold you responsible in a reasonable way for those rules set forth in the concept summaries. And I want to then move this along to legality. And as I point out, the Exhibit 13-2 contract legality on page 65 of the book, the authors do a good job in explaining the material on those pages regarding contracts contrary to statute, for example, gambling contracts, or contracts contrary to public policy. But I want to focus on the category of contracts in restraint of trade under the contracts contrary to public policy that the authors have in that chart. And more specifically, I want to spend a little bit of time in addressing contracts that contain covenants not to compete, sometimes referred to as anti-competition clauses or contracts. The idea of a covenant, by the way, is an old-fashioned way to talk about an agreement. It's often in reference to some biblical term, but a covenant not to compete or a promise not to compete can come up in business sale contracts, and they can come up in employment contracts. And so an example I've put forth in the posting is you want to buy a pizza business located in South Buffalo. I don't know why I picked South Buffalo, but I did. And so you're the purchaser, and you're going to buy the business. And one thing you ought to be concerned about, and more specifically, your lawyer better be on their toes, is that you want to make certain that after the sale is completed and you bought the pizza business, that your seller doesn't turn around and start competing with you. Because, word's going to get out that you're, especially if that's been a popular or a successful business, that the previous owner is in the neighborhood, and people, being the way they are going to go, well, don't go to this new place. Go to Joe's place. He's the original guy, or whatever. So what you're going to want to do is have a covenant not to compete in the contract of sale, and what you're going to want to do is have a clause or a provision that says after the sale, the seller, for a certain period of time and in a certain area, is going to not be able to compete with you. And there's all kinds of language that we want to use. I think the one takeaway we want to have about this is that the limitations have to be reasonable. The scope limitation, in other words, the area in which there can't be a competition has to be reasonable, and the duration has to be reasonable. And I know when I draft contracts like this, though I've never done a pizza business, I always refresh myself, because this is all common law judicial decisions, at least in New York. It's beginning to change in other states, and they're tightening it up because the idea is that too restrictive of a covenant impedes business. It impedes people's ability to make a living. So I get a sense of it in terms of the recent cases, but I'm thinking something like a couple of years, 2 years, and then in terms of the duration the scope, I would want to get a sense of what area that South Buffalo pizza business that we're buying, in what area do its customers generally come from. I think you're getting the drift. You can also see these covenants not to compete, as I said, in employment contracts. A while back, I represented a tennis center. They were hiring a pro, and they wanted to make certain that the pro wasn't going to walk out of the business with a loyal cadre of followers and go to a competitor. So we had a provision in there that if the pro left, the pro wouldn't be able to work in a certain area for a certain period of time. It's the same drift, but I had to be very careful, because a court's going to otherwise say you're too restrictive, and this person won't be able to earn a living, or you're impinging on that, and we're not going to enforce it. So that gives you a sense of covenant not to compete. And I'm going to stop this video so we can set up our next screenshot, which we can put in this video. So I've got another screen up. It's Chapter 5, Genuineness of Assent. We're just going to cover a part of this in this video, and then for week 7 to 8, we'll finish off this chapter. But at this point in the course, we've gone through the 4 requirements or elements for a valid contract: agreement, consideration, capacity, and legality. And the deal here is they may all be in place, but the contract may nevertheless be unenforceable if the parties have not genuinely assented or agreed to its terms. So the question becomes, well, what could adversely affect genuineness of assent? And then the chapter is divided into 6 different topics that might lead to the conclusion that there wasn't a genuineness of assent. And we're going to cover these topics, but not give equal weight to each. Again, I'm filtering the importance based upon, I think, what typically is going to happen in the real world. But certainly the first topic we want to spend some time on, because it can pop up, and that's mistake of fact. In other words, parties enter into a contract, they enter into their agreement, but one or all of them is laboring under a mistake of fact. And what we want to first do is make certain that in this category, we're aware that the law distinguishes between fact and value. So if I possess a painting, I know everything about the facts of the painting, right? There it is. I can see it. In the lower right, there's the name of the artist scrawled. But I'm not mistaken about any facts regarding the painting. What I might be mistaken about is its value. And let me just give you a quick thought about that. When I used to spend a lot of time in Florida, there were paintings that had been created by these men known as the Highwaymen. And there were these really cool paintings of old Florida. And they used to be sold on the side of the road. And as the years went by, they became valuable. The market became valuable. And a person I knew in Florida was driving down the road, and he saw somebody throwing out these paintings, and he stopped and said, let me pay you for them. And the person sold the paintings to him at a nominal cost. And what he ended up doing was getting, I suspect, over $5,000 worth of paintings for about $20. Now, the deal is that there wasn't any mistake of fact. There was just this huge mistake of value that the seller made. But the law of contracts, if you will, isn't worried about that or concerned about the mistake of value. So if we actually have a mistake of fact, we could divide it into two categories. One is a mistake of fact made by only one of the parties to the contract, and that's would be known as a unilateral mistake of fact. And if the mistake was made by all parties, we could say that it was a mutual mistake of fact. And the rules are the mistake of fact was unilateral, then the party making the mistake can rescind the contract, terminate it, if you will, only if the party not making the mistake knew or had reason to know of the mistake. If it's a mutual mistake of fact, then all parties have the ability to rescind or terminate the contract. A good example of a unilateral mistake of fact is the problem 14.5 on page 85. It's a real case. A person entered into a contract to settle a claim with an insurance company based upon his mistaken belief of fact as to the policy limits. It was a unilateral mistake, but clearly the insurance company knew what the policy limits were, so it was aware of the mistake, and the person who made the mistake, who settled with the insurance company, was able to rescind or terminate his contract with the insurance company, meaning he didn't have to take the settlement and he could renegotiate it. A mutual mistake of fact is in the famous case Raffles versus Wickelhaus, which I think is an English case, and the seller and buyer of cotton were mistaken about the ship that was going to be used to transport cotton being, I think, imported from India into England. There were two different ships named the Peerless, and the parties did not know this. Their mutual mistake of fact would have allowed either one of them to rescind the contract, so the party wishing to rescind or terminate was able to do so. Our next setup is fraud, and I'm going to be saying a lot more about it, but I think we've got time to identify the three elements of fraud. So this is another area where we have a problem with genuineness of assent. We've got a misrepresentation of a material or significant fact. It was made with an intent to deceive, and justifiable reliance by the other party on the misrepresentation. And I'll go through the elements of fraud in our next video, but that'll be in our next 2-week period. Thanks.